Okay, how was dinner? Everybody okay? Everybody got enough? Excellent. Okay, I'm just going to quickly go through a few tax issues now. First, I have to give a disclaimer. I'm not a tax lawyer, so this is all true. I just that I may not be able to explain it in tremendous depth, and I don't do that much. I don't do any tax planning, so. But I did share this with my tax partner, and this is all accurate. I guess what I really want to do is simply give you that, quite seriously though, give you the heads up that when you go to establish a new business, the structure you use will depend a lot on how you see things evolving and the kind of business that you're going to be in. And there can be some very helpful things you can do around tax structuring to mitigate tax liability. And that can be how you own your company, whether you do, you can split ownership so that if you do anticipate it being profitable and distributing dividends through the common shares, you might want to have those common shares owned by your children or by a family trust. And there's different advantages, different rules, there's certain limitations, but it's just, if you're going to be starting it as a family-owned business, or if you've got a spouse or a non-working spouse, there are some very interesting tax mitigation strategies that you can deploy. We could do a whole night on that, and we bring in a couple of our tax partners, and we will take you through it. In fact, I can chat after about whether that would be a topic of interest to you entrepreneurs. We'd be happy to do it. What I'm going to do just for the next few minutes is just highlight a little bit about when you have a small corporation, about some of the tax implications around that, and a couple of things you can do for tax minimization purposes. So we'll start with, I guess that's the CRA shaking you upside down, which is something I guess we've all got used to. Okay, so startup losses. As Nancy talked about in the beginning, whether you're a sole proprietor or if you are a partner in a partnership, the income or the losses of that business are those of the owners. So if you're a sole proprietor, the income of your business is your income. If you have losses, those losses can be used can be deducted against your income from other sources. So there are some very significant advantages, and I think when you've got a new company, like what my accountant said when my spouse was starting a new business, until you've got about $100,000 worth of income, it's just not worth having a corporation. That's because of the incorporation costs. You have to file a unique tax return. A corporate tax return is a bit more complex to take advantage of all the deductions that are available. You typically need an accountant. So until you're going to get up to that sort of size, as long as you don't have real risk concerns and you don't need the protection of limited liability, it's probably not worth having a corporation. But assuming your business is going to be successful and you're going to crest over that number, you are going to want to take advantage of some of the tax structuring opportunities. If you start off as a partnership or as a sole proprietor, you can roll the assets. You can basically transfer the assets into the business, on a tax deferred basis. And you can set, if you send the assets in, you can determine what value you attribute to the various assets you transfer into your corporation, which then sets their value for future depreciation purposes. So if you've got a bunch of assets that are depreciable, not all assets are, but most are, and different assets depreciate at different rates, the amount they depreciate each year can be used to deduct against your income. So you want to attribute as much value to the assets that have the fastest write-off, or the fastest deduction schedule, because you're sheltered the most amount of income. Slide. Sorry. Thank you. Okay, corporate taxation. So there are some very significant advantages to being a certain type of corporation, and that is being a Canadian-controlled private corporation, colloquially referred to as a CCPC. And because there's a lot of, I guess the main thing you have to be cognizant of is that to be a CCPC, CCPC, all of the shareholders have to be Canadian residents for tax purposes. And so, and that's important, that if your partner, for example, even though he's Canadian, goes offshore and files as a non-resident, because in Canada you pay tax based on residency, not on citizenship. So if people go to work abroad for a couple of years, they'll often try to take the filing position that they're non-resident, they don't have to pay tax, which is a great thing to do if you can do it. But if you're relying on your company being a CCPC, if any shareholder does that, it can compromise your classifications as a CCPC, and that's why we often put in shareholder agreements that everybody covenants that they will remain a resident of Canada and they won't cease to be a resident of Canada without getting the approval of the board. And typically, if that's going to happen, they'll transfer it into friendly hands while they're non-resident. We're going to go through 4 or 5 advantages of being a CCPC. First of all, we're going to talk about shreds. Any of those of you that are involved in any sort of business around that's involving new research have probably heard about the SHRED system. So SHRED stands for Scientific Research and Experimental Development. And the really cool thing about the SHRED program is it's very expansive in nature. Many activities will qualify as a SHRED qualifying activity. And I'm talking about anything from new farming techniques, anything that's new and novel and hasn't been done before, or if you're experimenting with a new technology, even a new business process sometimes, the expenditures around that research can be deductible. Now, there are many firms that have popped up, and we work with a few of them, and I know one of them quite well, that will go into your business or even look at your business plan and say, this could be eligible for SHRED, this could be, this can't be. And it can really be helpful in determining where you want to spend your money in the early going, because if you are involved in SHRED qualified expenditures as a CCPC, you can take, if you have $100,000 worth of qualifying SHRED expenses, you can take 35% of that cost and get a tax deduction for it. If you don't have income to deduct it against, you can get a 35% cash. You get 35% of that expenditure back from the government in cash. So it's actually a reasonable source of potential capital for your business if you're involved in SHRED qualifying activities. If you are a non-CCPC, that rate is simply lower. You're still welcome to use the program. It's a really great program. And again, to make sure you're not missing the advantage of the program, it's really worthwhile hiring one of these consultants to look at your plan and look at your business to help them identify where there might be SHRED eligible expenses. Click. Thank you. I also wanted to talk to you a little bit about a program that's not in here, but it is somewhat tax related. I met with an Ontario government official yesterday who was telling me about a new program whereby if you are a CCPC and if you receive an investment from either an angel investor, and to be an angel investor, that person who's investing in business has to be registered with an angel organization in Ontario that is a member of the NAO, the National Angel Organization, which is not a big deal to do. And if that person invests, for every $2 they invest in your business, the government will give you $1. So it's a very powerful tool, and same with VCs. So any VC money, they'll do that partial matching, and I think it's up to, I meant to bring the brochure up to me. I'm going to give Suresh and Lalit a soft copy of our presentation that they'll put up on the Thai website. I will put the little, I'll make a PDF of what he gave me. It's a really great program that I was not familiar with, and it's quite generous. I think it's up to $1 million. So really valuable thing to look at, and it's a provincial program. So I'm sorry I don't have more details of it with me right now, but it's It's available, and for you, those of you who are looking into Angels right now, you should be aware of that program because you can get another good chunk of money. And the money, they'll get it out to you in about 6 weeks, so it's really quick. It's a very efficient program as well. Okay, let's go to the small business deduction. And this is just as a small business and as a CCPC, your income is taxed at very favorable rates in the early days. So you'll see up here your first $500,000 of active business income is taxed at only 15.5%, and that's about as low as it gets. And then your general income, which is non-active income, and those definitions are a little bit peculiar, and I'm not going to get into it tonight, but they're also taxed at a very competitive rate of 28%. So, and I don't know if you knew this, but just because people bitch a lot about being overtaxed in this country, they're missing a point a little bit, because I did learn this week that we have the lowest corporate taxes in the entire G20 right now. So, you know, I think is making Canadian businesses, you know, very competitive, and I think the current government is very motivated to keep it that way. Capital gains exemption for CCPCs and for qualified small business corporations, which again, it's a certain classification you have to fit within, and I think it's probably too much detail to go in here. But if you sell shares in that business, so if you build your business and you are a qualified small business corporation, the first $750,000 that you make on the sale of those shares is tax-free. So it's very important you keep that in mind, especially if you sell your company fairly early in the going. A couple of important tax deferral opportunities that you should be familiar with. The deal is when you buy, if you get a stock option, we're going to talk a little bit about options. I'm sorry, we're going to talk about that off the top. So maybe when I finish this little tax thing, before we get into the security laws section, which Nancy's going to lead, we'll talk a little bit about options and how they're used and how they can be a great retention and recruiting tool. But if you get an option that's in a public company, and these are, most public companies have employee stock option plans for retention and rewarding purposes, is if the company grants you an option and it says that anytime in the next year you can exercise this option and if you pay 10 cents within that year, we'll give you a share. Well, if the fair market value of that share is 20 cents when you do that, even though you don't sell the share, you simply bought it for 10 cents, the difference between what you paid, 10 cents, and what its fair market value at the time you exercise the option is 20 cents. With a public company, that delta of 10 cents has to be included in income as a benefit. So it's a taxable benefit. The great thing about if you do that with a private corporation, a CCPC, you don't pay any tax on that until you actually sell the underlying share. So there are, you know, that's why options are attractive with private companies, is that as you exercise them, and options are great because they do two things. One, they create retention and loyalty for the people that you grant them to. Two, when they actually exercise them, they put money into the treasury. So they're just a way to create more capital as well as rewarding the people that have been good to your company. The small business share rollover. So to the extent that you have capital gains that are not sheltered, as we talked about earlier, to the extent that you're above that, you can defer the gain on the unsheltered part if you've sold a CCPC, as long as you redeploy those gains into a new business, a new CCPC, within 4 months. So often, a lot of you will probably evolve into being serial entrepreneurs where you're building businesses, selling it, starting another one, selling it. And a lot of guys do that, and many of them do that and do it very effectively. And if you're strategic about it, you can pay very little tax along that program. So just be aware, and very few people are aware of this program, that regardless of the size of your gain, as long as you redeploy it into another corporate CCPC, you can defer the capital gain liability on that sale. Okay, so that was a very brief tax overview, and I apologize a little bit for it being a bit of a flyby, but it's such a complex area that I think having a tax night wouldn't be a bad idea, and we're happy to build the content to do that. We're going to go into securities law issues around raising money by selling shares in your business, and this is really important that everybody understand this, and Nance will lead that discussion. Before we do though, maybe a couple folks asked us if we talk a little bit about options. I think they were raised earlier as well by one of the guests, and giving options in your business is quite common, and as we said, it's very wise to do it in a manner that's not ad hoc, that you have a very disciplined program about who is eligible to participate in the option plan and what are the terms of the option plan, and who decides what options are granted and what sort of matrix you use for determining how many options people will be entitled to. It's a very common way to retain people, because you'll grant the option, but you might grant 100,000 options, but they vest over time. And they might vest not only just over the passage of time, but they could be also subject to other milestones that you may customize for employees along the way. So they vest over time, but maybe they have to meet certain performance review hurdles and so on. So you can design whatever vesting qualifications you want, and it's often a really good tool for influencing certain behavior and for keeping really key employees. And I guess the trick is you want to be thoughtful about how you price them. And you also want to be thoughtful about how long they can be hanging out there before they have to be exercised. So one, they don't vest for a while, but then you don't want, once they vest, you don't want them to be exercisable over a 10-year period, because you might create tremendous value in your business, and when you gave them those options, they were exercisable at a very low price. So they could do quite a dilutive exercise of those options, but not put very much money in the bank. So typically you'll want to keep the period that they're alive relatively limited, and you want the vesting period to be stretched over time, but not too much time, because otherwise people don't attribute much value to them. So it's a bit of a balancing act.
Yeah, and also just when you do grant options, we usually build in provisions that if the person is terminated or quits, then the options would expire within a certain period of time, so that even if they leave the company, they aren't going to be out there for the full term.
What else?
I guess it's just the way that options are granted, because they are like a security. Basically, the board of directors would do a resolution to grant the options, and so the number of options and the price and the expiration date would be set at the beginning. And then when Craig talked about the vesting provisions, so basically you decide the number of options up front, but that people wouldn't be able to exercise them until they vested.
Yeah. So they're very common. But don't give them away like candy. That's because there's often a tendency for people to give out too many options, and the problem is when you go to meet a more sophisticated investor down the road, they think, well, gosh, you gave your equity away rather freely, which suggests that you're not attributing enough value to your business. So you can't talk out of your one side of your mouth, your business is worth so much, and that's why they have to pay this very high price, when you've been giving equity away quite easily. So you want to be fairly judicious in how you grant them, and you want to maybe only be granting them only to your most valuable employees.
And also keep track of the options that you grant, because a lot of companies we've seen that they'll grant options in consulting agreements or other commercial agreements. And they don't necessarily keep good records in the minute book, so they don't know exactly how many options they have, or they have to sort through all their records to find the agreements where they've granted options. And as a startup company, when you get down the road and the investors come and want to take a look at the books, if you're that unorganized, they get a little nervous that there may be a lot of other options or warrants or other types of rights out there for people to buy shares.
Yeah, so keep a very disciplined option and warrant ledger, so you always know what the status is. Another feature that's quite common, and more sophisticated senior employees will ask for this, is that if there is a change of control in the business, so if there's a sale of more than 50% of their shares, or if there's a sale of all of the assets of the business, that all their options vest. So they get the benefit of that, and see the company sold from under them before they get a chance to have their ownership recognized. So having vesting crystallize on a change of control is quite common, and you should be prepared to have a sophisticated senior employee negotiate for that.
Yeah, and unlike shares where, I mean, when shares are issued, you get a share certificate. When you grant options, generally you should have an option agreement that sets out all of these terms, because sometimes you'll have directors just grant options without all the details built into an option agreement. You'll probably want to have them non-transferable, so they can't sell them to a third party. You'll want to have built-in terms that say, yeah, if the company gets bought out or there's an amalgamation, that those people who hold those options have to take the shares of the new company if it's a share exchange, or they have to take the cash that they would have received at the time if they held shares. You sort of want to think ahead about what kind of transactions could come down the road and sort of predetermine what will happen with those options.
Yeah, and I think you alluded to this for consultants, but often the most common recipients of options are directors. And typically the deal will be, if they don't exercise in 30 days after resigning, often if they're removed for cause, then you often would have a thing that they're canceled. If they resign on their own volition and they're not supportive of the company anymore, they have to exercise within 30 days or they vaporize. That's because you don't want them hanging out there when they're not giving you any value. Okay, so over securities law.
So that kind of leads us right into securities law. Okay, I guess I mean, everybody here, I'm sure, understands how shares are issued from a corporate point of view. Generally, you have in your articles of incorporation, you have an authorized class of shares. And then to have those shares issued, the directors will pass a resolution setting the price that the shares are issued for and allotting them and issuing them to the specific shareholder. And that's all kept in, those records are all kept in the minute book, and a share certificate is issued in the name of that shareholder. A lot of things that private companies don't think about is when you issue shares, and there's corporate law requirements, but there's also securities law requirements. And the Securities Act, I should have brought my big blue book, but it's just stacked full of rules. And it's important to realize that whenever you issue a share, or even if you grant an option, those are securities, and you need to think about the Securities Act. Basically, there's some technical definitions in the Securities Act, like a security and a trade and a distribution. So basically, if you're issuing shares, it's a trade in securities. And it's a distribution if it's the first time the shares have been issued from Treasury. So when those three things happen, generally the rule in the Securities Act is that to issue shares, you have to have a prospectus. Now, many of you, I think, may be familiar with the prospectus, and it's basically when a company wants to distribute shares, they have to have this thick disclosure document that has full, true, and plain disclosure of all the material facts about the corporation. And it's very expensive to prepare. You need lawyers. You need to draft it, include all the important facts about the corporation. Well, it's not practical for a small company to go out and prepare a prospectus when they want to issue shares for seed capital or starting up. So the Securities Act has a list of exemptions. So they basically say, okay, you don't have to do a prospectus, but you have to find one of the exemptions we have listed in the Securities Act. So basically, you may be relying on these exemptions. If you've already issued shares from your corporations, you may have already relied on some of these exemptions automatically without even realizing it. But basically, if you are relying on an exemption, it's called a private placement. Oh,
sorry.
That's okay. I'm skipping ahead. It's called a private placement. So you've probably heard that term, public offering, private placement. It just means that you're issuing shares exempt from the prospectus requirements. Now, if you buy shares under a prospectus, those are freely tradable. They're cleared under the Securities Commission, so you can sell them to anyone who you wish to. But if you buy shares under an exemption from the prospectus requirements, then those shares are in what they call, you may have heard referred to as the closed system. So you basically cannot just go and sell those shares to anyone without relying on another exemption or following the resale rules under the securities laws. And again, a lot of probably private company transactions are completed without people realizing they may be relying on exemptions. There are some automatic ones that you probably do fit into, but I think you need to make sure you always raise the issue and ask the questions whenever there's a share issuance or a transfer of shares, whether or not you are complying with securities laws. Some of the exemptions that you may already be familiar with there's some capital raising exemptions. One of the most popular ones that we use for public companies, but you can also use for private companies, is the accredited investor exemption. This basically says if you issue shares to a person who's so sophisticated that they don't need the protection of a prospectus, that they can buy shares without the prospectus. And generally, there's a laundry list of who meets the definition of an accredited investor in the Securities Act. So generally, an individual who has an annual income of over $200,000 for the last 2 years, or together with their spouse have an income of over $300,000, they would meet the requirements of being an accredited investor. So you could issue shares to them, no problem. Another exemption that a lot of private companies at the startup level will rely on is the private issuer exemption. And private issuer exemption has sort of two portions to the test. First of all, you have to be a private issuer, which generally means you're not a reporting issuer, you've never been a public company. You have a restriction on the transfer of your shares in either your constating documents or a unanimous shareholders agreement. And that restriction on transfer, just to stop there for a minute, when we were talking about the articles of incorporation earlier, how we create the company, a lot of companies, when we first incorporate them, we automatically usually put a restriction on the transfer of the shares. So we say, none of the shares of the corporation can be transferred without the consent of the majority of the directors or a majority of the shareholders. So if you have that in your articles of incorporation, then you can check off the box, one of the boxes beside this private issuer exemption. In order to rely on this exemption, you can only have 50 shareholders, not including employees, directors, officers of the company. So you have those 3 requirements you have to meet to be a private issuer. If you meet all those requirements, then you can issue shares to a certain list of people again. So it goes down to people that are that may be relatives or friends of the directors and officers or founders. An accredited investor as well would be included in that list, or other certain people that are close to the company and business. You can't go out to a person who's deemed to be the public, a person walking down the street. You can't just go up to them and offer them shares. You have to make sure that you fit within these exemptions. A lot of times when you're first incorporating your company, there's an exemption for founders, controlled persons. So when you're issuing those first shares to your founders, you're actually relying on an exemption but not even realizing it. It becomes more important when you start getting real financing coming in from like business associates or angel investors or other outside groups, where you really need to make sure that there is an exemption if you don't think you'll automatically be able to rely on the private issuer one or the founder one. So it's always important to know who you're issuing shares to and making sure you have an exemption. One of the other exemptions is the $150,000 exemption. So basically, if anyone is sophisticated enough or dumb enough to put $150,000 in to your company, everybody thinks that they should be able to do what they want with their money. Which kind of doesn't make a lot of sense to me, because it sort of forces them to go up to a certain threshold to rely on the exemption, when if they really wanted to, they may have put less in for such a risky venture. There's also a whole group of exemptions related to transaction exemptions. So once you are a corporation, if you down the road you are taken over by somebody, or you merge with another company, there's shares issued as part of the acquisition, there's exemptions provided for that type of transaction as well. But I think just the takeaways, like anytime you issue a share or a security, which includes options, if you grant options, just make sure you have an exemption. So if you're issuing options to a consultant, you need to make sure that that consultant meets one of the exemptions under securities laws.
Yes, what about often you'll have a corporation who's ends up with a creditor. They can't pay, and they go, look, can we give you shares instead?
There's an
exemption. There's
an exemption for debt, which was added recently.
Okay, any questions about the securities law compliance stuff before we move on to a few of the value drivers? Everybody good? Everybody understood? Okay, fantastic. So, value drivers. By this I mean, what are, the slide you can read along. So these are basically rules and disciplines that we've seen that end up being, operating and organizational factors that can really have significant value, and that typically the management and the board of the company can have some control over. And it's as we talked about in the beginning, if you can establish really disciplined best practices for the operation of your business, the maintenance of your records, the simplicity of your share structure, and you're really good about that, and it's all buttoned down, when an investor comes in, a significant investor comes in to look at your business, and they lift the hood on your business to have a good look at it, and they start doing their due diligence, and they see you've demonstrated that discipline from the beginning, one, it'll give them great confidence in the management team, and two, it will give them way fewer levers to push on to try to drive the value down. So this can really positively impact the value of your business when you're going out to look for your significant rounds of financing. So one of the first ones is shareholder composition. We talked about at the beginning that if you can, avoid having, desperate times require desperate measures. You need money, you get it wherever you want, wherever you can find it. And every entrepreneur has been there and knows that typically the barrier and the reason most small businesses fail is because they're not adequately capitalized. So everybody's on the hunt for money all the time, and it's a very competitive world out there looking for money. What people end up doing is they'll take $20 from me and $100 from Suresh, and they end up with way too many shareholders. And you can wrap these people up in a shareholders agreement, and no matter what you do, don't start issuing shares without getting people into a shareholders agreement, because once they own a little bit, they get lots of rights associated with that share ownership, including if they want to suggest that you're not treating them fairly, you're not giving them the information they need, you're doing something it's contrary to minority shareholders' interests, they can bring an action for an oppression remedy. There's all sorts of power that a small shareholder can have against a company. And the best way to control that is be very thoughtful about what you want the rules of operation for your business to be. Codify that in a shareholders agreement, and then make sure everybody signs it. And make it a rule that shares aren't validly issued to anybody until they sign that agreement. And that will keep people motivated to get their income to pay. We talked about this earlier. Keeping your share capital structure as simple as you can. Investors will always want to ensure that they have the advantage. So the big investors. So if you end up with a whole bunch of, you have a special class for mom, a special class for dad, a special class for brother Bobby, they're going to require that you restructure all that, which costs a bunch of money. Will often require evaluation. Try to keep yourself with just common shares until you absolutely need to issue preference shares, and the terms of those preference shares will typically be driven by the investor. Minimize dilution drivers, and by this I mean we talked about earlier how when an investor comes in, they're going to look at your business on a fully diluted basis. They're going to want to know what's the share landscape look like when everybody exercises their options, their warrants, their convertible debentures, and then they're going to decide how much stock they need to buy to get to the position of control that they want. So if you have a bunch of options and warrants and things out there, it can be problematic. And what you might want to have is that if we're going to do a major financing, we're going to deal with all those. We're going to crystallize all those conversion rights in advance, just to make life simpler when dealing with a larger investor. Limit shareholder vetoes. What you'll often see in shareholder agreements is that you'll have someone will come in and they'll say, even though I only own 15% of the business, there's no way you can sell all the assets of the business, or there's no way you can borrow over a certain amount, or there's no way you can enter into this field of activity without my consent. It's just having them possess that veto that can be a real anchor on management of the company, and the problem is when you're desperate for money and people are trying to put conditions around the delivery of that money, you'll feel really compelled to fold and concede to their demands. but try to limit that as much as you can. And the ones that are not uncommon or not unreasonable is borrowing over a investors don't want you to see throwing tons of debt, particularly secured debt, on top of their interest. Because you have to remember, in an insolvency, it's the shareholders who get paid last. So the secured creditors get paid first, the unsecured creditors get paid second, and the shareholders get paid third, and like the preferred share guys go before the commons, and the commons go last. So if you're the founder and you got common shares, there's a lot of people ahead of you. So just expect that a large investor is going to want to have a control on how much debt you mount on above them. Control is, people don't want to see too much control vested in a minority shareholder. It can be very dangerous. Now, often minority shareholders are also very strategic because they bring more to your business than cash. They may bring access to a distribution channel, they may bring access to technology, they may have rolled in a technology that they've licensed to you on an exclusive basis as long as they're a shareholder, and they've sort of got you by the toes if you become very dependent on that asset they've brought in. But if you're going to bring in people that bring a really unique strategic advantage to your business, you can expect that they're going to be looking for some special favors. And just have to sit down with counsel and make sure you understand what are the implications going to be if they try to exercise those rights, and can they really frustrate our ability to lead the company forward. I hate to say it with a good banker in the room, but try to minimize your secured debt obligations, because I said above, when the preferred shareholder comes in, when the venture capital or equity private or preferred equity investor comes in, the one person that's going to be ahead of them is the bank. So if you can avoid getting a general security agreement granted over all the assets of your business, or if you have a really critical piece of property and there's a first mortgage on it, if you can avoid having your critical assets of your business encumbered by lenders above you, it's going to reduce the anxiety of your large shareholders, because they will participate in the dissolution process of the business if things don't go well. Liquidity bombs. These are, again, little features that investors may demand along the way that you should be very careful about accepting. The most common one is a put. So a shareholder comes in and says, you know what, I really believe in you. I think it's a great concept. I'm gonna put in $1 million, but I want a special class of shares. And one of the features of those shares is going to say, if you don't, by way of preferred dividends, return a certain amount of money to me that gives them a certain prescribed return within a certain period, I can then put my shares back to you at a price that will guarantee I got that 7% cumulative return. And this is absolutely common in venture capital firms and private equity firms. They will drive that at you all day long. And often that money is transformational money for your business, so you're just going to have to go with it. But it's really important that you understand that if you want to bring in someone after them, they're going to be really anxious about that. Because if that time period comes and they exercise that put, it's going to put tremendous stress on the financial resources of the business and can cripple the guy that comes in after them. So it can be a real barrier to subsequent financing. Now, hopefully what you do is when you give into that equity or that built-in liquidity bomb like that, and you give a guy a put, you have a little upside that says, if we meet certain performance thresholds, whether they be sales or net profit, I mean, you can develop all sorts of different matrix, but if we achieve them, you will put in more money, so that you don't have to worry about getting another investor to come in who's going to be very deterred by this prior right. So if you're going to take that pain, make sure you get some benefit out of it. And good counsel will sort of walk you through that. When a major investor comes along, they're going to be looking at two things. One, they're going to want to see if you have something that's unique, just you have some unique offering, that there's an addressable market for what you've got, and that the team that's driving it is the right team, and that right team is motivated to stick around. Every investor, every private equity conference you go to, the company owners put the hang on, what are you looking for when you're deciding on what company to invest in? They always list about three things. The first thing is the quality of the management team. So the quality of that management team is of little value if they can walk out the door if they see something shining down the road. So the way to keep them signed up is to make sure they have skin in the game. And you can make sure they have skin in the game by two ways. One, they put real bucks into it. Two, they have deferred compensation that they get only if they stick around. And three, that they have options that vest only with the passage of time and the achievement of certain performance thresholds. So you want to make sure you lock up your key people, and not just with an employment agreement and a non-comp agreement, because those are more just defensive strategies. People can leave their employment whenever they want. You can't, there's no indentured serfdom in this country. So people can leave, but what you don't want them to do is compete. So you want to make sure that your management guys have non-competes that are not too broad, because if they're too broad, they're not enforceable and they're worth nothing. So you want them to be relatively carefully confined to your specific industry, and they can't be too long, because if they're too long, courts won't enforce those either, because they think they're unfairly restrictive on a person's ability to make a living. So you have to, and what I typically do is tell clients they're worth nothing. Because if they break it, it's, particularly if you're in financial distress, the last thing you're going to do is use your precious dollars to go and fight a lawsuit for the competition. So what you want to do is you rely less on your defensive strategies and more on your offensive strategies, and that's by making sure they're happy, they're skin in the game, and they're really motivated to see the company be successful. Just around that, so that management don't feel when people don't feel they know the whole story, they can get really paranoid. And they can get really paranoid if they think they're being left out of the plan, if they feel they could be marginalized, if the company's going in a direction where the value they bring to the enterprise is no longer going to be as valuable, if they think there's a risk of bringing someone else in, if the company's in financial distress. Having as much transparency as you can really helps people feel, one, that they're fully engaged, two, that they're trusted, and three, that they're part of the team. And not all entrepreneurs are comfortable doing that. A lot of entrepreneurs like to keep their cards really close to their chest. It's my baby, you just do what you're told, you're fairly paid, that's all you need to know. I just find that it's very hard to keep really talented people if you treat them like that. So everybody has their own style, but I think you'll find that if the more inclusive and transparent you are, and you can be transparent, particularly if you are adopting and demonstrating best practices from the get-go. In fact, you can be very proud of it, and you can actually influence behavior by leading by example. So I think, all of you that are going to be owners and managers, just be the manager that you would want to work for. Okay, that's not a bad rule of thumb. And again, demonstrate best practices from the beginning. And as I said, if it's demonstrable, if the way your records are kept, if it's the quality of your employment agreements, if it's the careful protection you've done around your intellectual property, if it's the way that you've managed your financial resources. When a sophisticated investor does their due diligence, they're going to do financial due diligence, business due diligence, legal due diligence. If they see all that in order, it gives them tremendous confidence, in the management team, and in the value that you're saying the company is worth. And then I guess this is the arrow into the dollar sign, and this is just back to the beginning, that what I have way too often seen in being counsel to entrepreneurs are always chasing revenue because they need to eat, you need to keep the lights on, they need to hire more employees, they need to pay for patents, so they're just driving revenue, chasing revenue all the time. And the last thing they want to worry about is whether the minute book's up to date, whether they filed, they filed their they got their remittances. They're just chasing revenue all the time, and there's a tremendous temptation to let stuff slide. And the more you can do about adopting a very serious discipline about best practices and just make it mission critical and indoctrinate your key management team members to that philosophy, it will, I just absolutely assure you, you will see it create and maintain value in your business on a going forward basis. There's a bunch of stuff that we're gonna, look, the Thai Institute's done absolutely, and I salute my directors and the lead and Suresh in particular have led the charge on the development of this institute. They're building great content. There's a lot of stuff, a lot more stuff that we can talk about, and we look forward to working with the guys to build more content. We'd love to have you back. Again, we're going to put the presentation and that little thing I got from the provincial government the other day on the Thai website. You can go there, and Nancy and I would be happy to answer any questions that you may have now. And if there's things you'd like to ask us in private another time, our contact information is up there. Police mine, but I'll give you Nancy's direct number. But Ty can give you all that, and we'd be happy to work with you guys or answer any questions you've got at any time. Just do one last little plug for the firm. We are going to be launching a new program in the next few months, where and we're reserving a spot for the winner or the winners of TaiQuest, but we are developing a program where we see companies with exceptional potential, and we're putting together a committee to assess applicants. We see a company with exceptional potential, but they just can't afford these big firm rates, and our firms are, and all these big firms are expensive, and we're embarrassed by it, but we can't change it. And we're not about to change it, so help me God. But I say it quite glibly because this program is actually about addressing that problem. There is a service gap, and great young companies need sophisticated services. And we are going to follow the example of a few of the great law firms down in Silicon Valley, most namely Wilson Sonsini, which has been counsel to more of the great tech startups and great now huge tech success stories than any other law firm in America. And what they did is they were rigorous about finding great young companies who couldn't afford their services, and they brought them in on a deep discounted basis for a few years. And they took a little bit of equity with them, and they made a deal that, hey, if you get a big financing or if you sell that company, we will not only get all those deferred fees that we have at risk, but we'll get a nice big premium on that. So we'll align our risk with you. So if you have a company that you think has exceptional potential and you're really excited about it, give me a call. Love to have you in and talk about it and see if you might be eligible for the program. So, thank you very much.
Greg and Nancy, so much to cover in so little time and so much yet left. Thank you so much for covering structure, taxation, governance, value chain, and so much more. Thank you for announcing this new program for your organization. We'll put it up on the web. And we look forward to the information of the provincial
Absolutely.
program, and we'll put that as well.